A financial exploitation case comes to my attention through referrals from law enforcement, which consists of reports from law enforcement, the adult protection worker. I review that referral and I make a charging decision. The most common evidence that we use are the financial records. What's helpful is showing the history of the vulnerable adult, that prior to the suspect gaining access to their finances or their property, that they had a certain routine, that they kept a certain amount in their account, that they only spent their money on certain items like utilities, groceries, medical, etc. And then after the point of the suspect getting access to their finances, that there's these wild expenditures that don't make any sense given the history of this particular person. In order to prosecute a case, you don't necessarily need the victim. Sometimes the victim has Alzheimer's or dementia and they're not competent to testify. So what we would then rely upon are the statements by the defendant to law enforcement or the adult protection worker, the financial records, the receipts, any videos, any observations of witnesses of what the defendant was doing. Family members should be preserving those items that are usually not kept by financial institutions, receipts, items showing signatures on credit card receipts, especially if they sign their name. If they try to forge the vulnerable adult's name, that is supremely helpful. They can even take down notes of what they've observed. The defendant went and purchased a birthday party at Chuck E. Cheese and the vulnerable adult had nothing to do with it. Items like that. Best witnesses are the caregivers and the adult protection workers, because the adult protection workers visit their clients on a regular interval, so they can notice signs that something isn't right. A police officer is quite valuable because they interview witnesses and they get statements and they're usually recorded. If there's anything that the adult protection worker hasn't done an investigation on, the police can do that. If the suspect has a power of attorney designation, my approach changes slightly. You can still charge financial exploitation of a vulnerable adult because you have that fiduciary relationship. However, I can't charge theft. Theft in Minnesota is defined as taking an item, personal property or services without a claim of right. That power of attorney, if they check the box that permits the fiduciary to transfer property to themselves, then I don't have that without claim of right anymore, because the vulnerable adult has, or the person who executed the power of attorney has given that away. So I can't charge theft, but I'm still left with financial exploitation. One reason to prosecute these cases is because you want to get the dignity back for the person. They may not realize what's going on, but I always want them to have some dignity in this, and the taking of their property just because of their state that they're in is not right.